Hi, welcome to Journey to Justice. I'm Eiko Kosasa, and today's program is part 2 of a 2-part series with Maivan Clech Lam, Professor Emeritus of the City University of New York Graduate Center and a well-respected legal scholar. In this part, I asked Lam to clarify the function and scope of the United Nations Declaration on the Rights of Indigenous Peoples. Is it a useful document? Does it hinder or help a people's struggle for independence?
Okay, I will try my best because it is at first a bit daunting, but perhaps I can start with a very simple illustration. Bolivia is a state that is run by an indigenous activist who became its president, Evo Morales. Okay? Right. So he governs both indigenous and non-indigenous peoples, okay? And he's the first indigenous person to govern any Latin American state. So that was a fantastic development, and you know, and it really happened with an extraordinary man. President Morales is a boon sent from heaven to us all, is all as I can say. So what does an indigenous president of an independent country, meaning independent from the US, independent from Spain, independent from other country, do about the indigenous peoples? As a state member of the UN, he has to follow international law rules that apply to all states, okay? So in that respect, there are certain things that must be accorded equally to citizens regardless of their ethnicity and race in Bolivia as in any other state. Okay. On the other hand, the Indigenous Declaration on the Rights of the UN Declaration on the Rights of Indigenous Peoples, which we now call the UNDRIP as the acronym, that allows states to carve out a special legal approach to the indigenous peoples living within multi-ethnic states. Okay? And even though the president of Bolivia is indigenous, that doesn't mean to say that the indigenous peoples of Bolivia are necessarily protected, right? Because he is the president of both indigenous and non-indigenous. But being who he is, as brilliant as he is and as principled as he is using every international law instrument available to him, right, to in fact address the special conditions and problems of the indigenous peoples of Bolivia. And the UN Declaration on the Rights of Indigenous Peoples is marvelous in that respect because it allows, under the normative framework of international law, for him to do precisely that. So, for example, he has amended with the usual, the legal process in Bolivia, using the legal process in Bolivia, the Bolivian constitution to ensure that a number of seats to their Congress or legislature is dedicated to indigenous representatives, for example. And he has also pushed through laws that allow indigenous communities to administer a large area of justice themselves according to their own customary laws. Okay, so now here's an example of an indigenous president running a multi-ethnic state where the UNDRIP fully applies to the indigenous peoples there. On the other hand, you know, you could also have an indigenous people, such as in Hawaii, right, who in exercising their right of self-determination say, we'd like to be independent of the United States. Okay. The trick here is that the minute an indigenous population chooses, or rather exercises the right of self-determination under international law to form a state and become a state, then they immediately have to treat people at a certain level equally regardless of their ethnicity. Okay? So I'm sure that this is not as clear as I would like it to be. But my mantra is, for the Kanaka-Somali struggle in Hawaii, can and I believe should look at reversing the history of American colonialism by looking at this as a struggle for self-determination, which allows you to opt for independence, sovereignty, and also a struggle for an independent sovereign state that will particularly promote, protect the needs and communities of indigenous people. So it's really sovereignty plus indigenous rights, or independence plus indigenous rights. It's not either or.
Wow. Yeah, because people think of the Declaration as it's not as good of a vehicle for independence, but that's not its function.
It's not its function at all. Thank you very much. Let me take the case of my own native country, Vietnam. Okay? I belong to the majority ethnic group in Vietnam. We call ourselves the Kin people. We have lots of indigenous peoples who typically live in the mountainside. And the majority people, Kin people in Vietnam, are constantly moving upwards and encroaching on the territories of indigenous peoples. Now, we fought a classic battle of independence, decolonization against the French, of which we're very justly proud, right? And so we solved that problem against the French. But the problem of the majority people encroaching on the lives, communities, and territories of the indigenous peoples who live in Vietnam is not at all on the table in the original independence struggle. Okay, so to the extent that we, the Vietnamese majority Kin people, are moving up into the territories of our indigenous peoples, we are being a settler colony vis-a-vis them.
Right.
And therefore, they need the United Nations Declaration on the Rights of Indigenous Peoples to help them, right, reverse the kinds of laws that the majority of Vietnamese have been passing, such as logging the forests and damming up rivers, that are destroying the rights of the indigenous peoples of Vietnam guaranteed to them by the declaration. In fact, if you look at the third world, virtually all of which has now been decolonized, the second decolonization movement, I call it, the second decolonization moment has not yet been perfected. And that movement, or that moment, the second decolonization is that of decolonizing indigenous peoples from the settler communities that have, intruded upon them.
Wow. Wow. Okay.
I hope that makes sense.
Yeah, it's much clearer, and to me it makes sense of the distinction and the function of the declaration. I keep wanting to call it the draft declaration because
it is no longer the draft. Yeah. Yes, now we just call it the UNDRIP.
Yeah, the UNDRIP. Wow. No, and then as it applies to Hawaii, because there's big fights, or misunderstandings of what that means. And especially, I think I had mentioned to you, they had said, what was it in the article 44, 45 of that, and that was on,
Oh, I'm so glad you brought that up, Echo, because I have the declaration right here in my hand, and what they're referring to is Article 46. And Article 46 basically says that nothing in this declaration may be interpreted as authorizing or encouraging any action which would dismember or impair, totally or in part, the territorial integrity or political unity of a sovereign and independent state. Okay, now, two things I would like to say. First of all, people need to know that international law, in particular, is full of paradoxical impulses. So on the one hand, it absolutely elevates the right of a people to self-determination. And that means that they can choose to be independent of any other people if they so wish. Okay? Any other people organized as a state. They can't do ethnocide for people who lives with them, but they can reject any other state, right, and form their own. That's the right of all peoples, indigenous or otherwise. Okay. On the other hand, international law is also worried, about a country like the United States going abroad and swallowing up Iraq, swallowing up Afghanistan, swallowing up Libya, it could go on and on, right? So it also defends the territorial integrity of existing states. But whom does it defend it against? Not their own people, not their constituent people. It defends the territorial integrity of Libya from being swallowed up by the United States. So it defends it against other states. Okay, so in law, you almost always have to ask, who is forbidden from doing what, and who is allowed to do what. The who and the what are absolutely critical. I might even say this is so relevant to the Rice versus Cayetano case, where the court said the who is a state agency, i.e. OHA. They don't care whether it's OHA, the Department of Motor Vehicle Registration, as long as it's a state agency, that's the who that cannot do. Then the next question is, cannot do what? Cannot hold an election based on race, because the 13th Amendment of the US Constitution, repudiating as it does the whole history of slavery in the US, said you cannot bar people from participating in an election on the basis of race if the who is a state, right? Mm-hmm. Now, if Kanaka Maoli themselves, not a state yet, right, today decide to organize an election among themselves, Rice versus Cayetano has nothing to say to them, because they are not a state, therefore they are not the who is forbidden to hold a racially determined election, okay? But that doesn't mean to say that a state, the right who cannot do anything. The state, and that's why the federal government can have special programs for minority children, can have special programs for the elderly and the sick, right? Mm-hmm. It is only elections that are forbidden to be constructed on the basis of race. So Rice, and that's the 13th Amendment. Okay. All the other programs that are, ethnic sensitive fall under the 14th Amendment. And Rice versus Cayetano said nothing about the OHA elections violating the 14th Amendment. The people who brought Rice asked the Supreme Court to say, isn't it true that this OHA election violates the 13th Amendment prohibition against having a state agency hold a race-based election? And isn't it true that this state agency is also violating the 14th Amendment, which forbids a state agency from doing anything that's ethnically sensitive? And the Supreme Court says, we agree with you on the 13th, but we are not agreeing with you on the 14th Amendment. So Rice versus Cayetano left all the programs intact. And the Kanaka Maoli population has been, I believe, purposefully led to believe that Rice versus Cayetano, means much more than it did, that all of your programs are under threat. No, only if you let a state run an election where only Kanaka Maoli vote, that and that only has been declared unlawful.
Wow. And so because of this misunderstanding with the Akaka Bill, that's why the state is using that misunderstanding to push the Akaka Bill, saying you're going to lose your entitlements,
exactly.
Right?
That absolutely is the boogeyman that has been erected to push people to accept the Akaka Bill. And the thing that is so ironic is that the apology resolution was a wonderful resolution, because it basically is what in legal terms we call an admission against interest. If I say to a court, yes, I murdered my neighbor, that is called an admission against my interest, because I'm saying something that really doesn't help me. Right. Would I be telling an untruth? Probably not. I'm not likely to tell a lie about something that hurts me.
Right.
So that is called an admission against interest. So admissions against interest have high evidence value in a court, because it's not likely to be a lie, it's likely to be God's truth, right? I murdered my neighbor. Right. Assuming I'm mentally competent, I'm not going to say something like that unless it is true.
Right.
So when the United States says, we admit that the Kanaka Maoli never ever agreed to give up their sovereignty, that's an admission against the interests of the United States. High value as to its truth in any tribunal, national or international. So that was, everybody knew that, Kanaka Maoli knew that, but to have the opponent himself admit that, yes, that's true, they have never given us their sovereignty, so how come you're holding, this power over them, right? I mean, so that is like a wonderful piece of legal evidence that will stand the Kanaka Maoli case in very good stead in any political or judicial tribunal internationally, be it the General Assembly or some other international tribunal. And And the people in Washington are not stupid. That was Bill Clinton being touchy-feely. Oh yes, I apologize, I'm so sorry. Then they thought, wait a second, that's a pretty bad admission he just made. That could come to haunt us. So we better have the Akaka Bill, which says, okay, but now you agree to hand over your sovereignty.
Yeah.
So that if the Hawaiians had agreed to do what the Akaka Bill proposed them to do, which is to have a vote and say, yes, we agree with the Akaka Bill, then that nullifies the apology resolution.
Right. Right. Wow. You know, this is a little bit off the topic, but this is what I hear a lot in the community. And when it's almost like, is there any law that cannot be changed? You know, like they're saying, if they did that, then they lost sovereignty forever. You know, Hawaiians, if they supported the Akaka Bill or had to vote in some kind of thing, it means they lost their claims. Right, to be a nation. Is that
that's an interesting question, because it applies to more than just the question of you know, sovereignty. People have a mistaken, and often people think that law is written in stone forevermore. You know, that would be dreadful if law were written in stone forevermore. First of all, law cannot anticipate changed circumstances. So of course, a law that is helpful to human communities, and it's not worth being called or respected if it's not helpful to human communities. It should worship humans, humans should not worship the law. Okay? So a law that is a servant of humanity needs to change with the needs and circumstances of humanity. And that is a real issue. Many legal systems are very good about providing processes for change, and some are not as good. That's just on the process level. Then of course come the people with vested interests. So when their vested interest tells them that they want the law to be read as it was yesterday, you know, then they will say that's a law, it can't change. So you have the Rehnquist court and now the Roberts court. You know, they don't like change. They don't like the fact that there are all of these new norms, new values we hold. So they go back and they want us to go back to the time when only landed white males voted, you know, and so on. So they say the original intent matters. So they're the ones who argue for set in stone because they can't stand the changes, okay?
Right.
But human societies always change. So a decent legal regime must understand that it has to be processed through history in a predictable, fair way, but nevertheless processed through, okay? So my view is that that is the fundamental approach to how law should work, that a lot of lawyers, you know, who understand the relationship between society and law agree to. Now, as for the act of self-determination, the question that does come up is, if, let us say tomorrow, right, people on Guam, for example, vote on whether they want to remain part of the United States administration, or they want to vote for independence, right? The answer to that question will depend on three things. First of all, who gets to vote? And we know that from the Kanaka Maoli case, when the 1959 statehood vote, that all kinds of people whose ancestors were not present when the original harm was done at annexation. Right. You know, so there was a harm which needs to be corrected. So how come people who just came to the islands like me get to decide on how to correct a harm that my ancestors were not even present at and did not suffer? Right. I should have no say in this. Right. Okay? But in 1959, they gave the say on statehood to people who probably had, you know, the minimum residency here. It had nothing to do with the historical era. So first of all, when you have a referendum on self-determination, it's critical who gets the vote. Right. Second critical point is, what is the question asked? And as you know, in Hawaii 1959, the question asked did not include, would you like to be independent? Right. So that flaws the process totally right there. Both who got to vote and the question asked or not asked. The third question, and this is particularly relevant in the discussions in Guam right now on a referendum about whether it wants to remain a part of the United States or choose other options, such as form some kind of reviewable association with the United States or opt fully for independence, is when is this question going to be put out? And the when depends on how much real and fair and thorough exposure to the options have the people on Guam been given been given. If the airwaves, if the press, if the educational system is run entirely by the oppressor U.S. state, and then that oppressor U.S. state with its relatively, I think I might be able to say, you know, a government that is in fact under the plenary power of Congress, that is by definition a puppet government, is not a real government.
Right.
So if the United States federal government, in conjunction with the government that is the puppet government, together control the flow of knowledge, of information, and decide, okay, tomorrow we're having a vote, that is not a free, informed vote. Right. So you have to have the right suffrage, the right questions, and the right background in airing the issues. Right. Do you see what I'm saying?
Yeah.
And in a way, this reminds me of another thing that the UNDRIP does beautifully, Echo. The UNDRIP, in my view, the strongest points about it is that it states itself that indigenous peoples have the right to self-determination in exactly the same words in which that language was used to effectuate independence for the third world from their extractive colonial masters. So the same language for used in the extractive colonial situation is now available in the settler colonial situation. So it's the same right, right? Okay, now granted that if an indigenous community chooses independence, you know, if the time comes that they actually do that, assert that, and transform themselves into a state rather than stay an indigenous community, then at that time they can no longer remain mono-ethnic, because that's what happens. But if you remain an indigenous community, you can decide whether you want to stay uni-ethnic or multi-ethnic in your indigenous community. You see? That's the difference. But apart from the self-determination provision in the Declaration, there's another super important concept in the UNDRIP. It's called the concept of free, prior, and informed consent. It appears 6 different times. Okay. And what it says is that nothing can happen to or on indigenous lands, territories, without their free, prior, and informed consent. Now, you know, that's like, if we immediately begin to apply that right here in Hawaii, that would already be a potent tool to stop and reverse all kinds of intrusion on Kanaka Maoli lands and resources. Right. And President Obama just signed the declaration early this year. This is what the state legislature should be immediately asked to do. You know, apply the concept of free, prior, informed consent to Kanaka Maoli resources and lands and territories, including fisheries, as right now, the second, because that's already the norm that the president has adopted on behalf of all the U.S. system, and the state government is part of the U.S. system in the fundamental, you know, international norms do apply to states. Wow. Okay, and there also the informed part is very important. I have actually been asked to give a workshop on this at the UN Permanent Forum on what kind of meaning does prior informed consent mean. And well, free means no coercion, material or physical. Prior means you've got to ask for that consent before the first shovel goes into the ground, right? Because afterwards, then, you know, you've already sort of moved things along so far that it's very difficult to reverse. So you don't want to say, oh, I forgot about that norm, let's do it right now, and tomorrow we dedicate the new hotel. That's ridiculous, right? So before the first shovel goes in. The third issue is much more interesting, informed consent. What is informed? And that goes back to what I spoke on earlier about the vote in Guam. Right. In my view, right now in the U.S. system, and we are administered by the U.S. right now, we're in an administered territory of the United States under, you know, the UN scheme of things as established in 1945. In an environmental impact statement here, before some development goes through, it's the developer who puts money into hiring experts to write up this thick document about, okay, here are the expected impacts, they are minimal, nobody's going to be hurt that much, and here's what we're going to do to mitigate it. It's all hunky-dory, you should all approve of this. Then these technical, dense statements available at the public library or some such. You have to trek to, and you got to read all this language which is, you know, purposefully obscure, so you sort of give up on it, right? And then you have, like, you know, a minimum amount of time to read it, and then you show up at the meeting and you say, well, I don't like what you said on page 10, on page 20, and I haven't read page 200, so I can't comment on that, you know, that sort of thing. And then say, thank you very much for your testimony, and they go back and they revise that statement to just sort of make it look better, and then it passes, and that's it. And that's as much input as we essentially have, right? Citizens, indigenous or otherwise. So I wrote in this paper for the UN that the informed part is critical, that we have, and I use an analogy from American domestic law. When you have a case that goes to court, two sides disagree vehemently about something, that's why they're in court, and the judge asks for two briefs submitted. A, you tell me your side of the story the best you can. B, you tell me your side of the story the best you can, right? And so how is it that when a development project that totally disrupts an indigenous community does not get at least the same deference, meaning a full briefing by both sides? Well, first of all, it's not in the law. Only the developer gets to say, and you get to respond if you understand and have the time, you know, to do it, right? So this is a much more serious matter, and only one side gets to air the knowledge or the information. So I have proposed, and there's no reason why, using the free, prior, and informed consent mandate in the UNDRIP, we do not sort of say here in the state legislature. And the way we decide to implement it in Hawaii is that it's got to be informed. And informed means that any time a developer asks for a permit and begins to spend $1 on hiring an expert, he must put the same dollar in an escrow account for the community affected to use to hire their expert so then the developer gets to read the 500 pages that this side, you know, has written up with its experts and vice versa. At the very least, you see, now this is not talking about independence. This is talking about on the way to independence, in order that you not lose too much on the way to independence, you should already be doing this. And even after the independence, if you get a Bolivia situation, still as an indigenous community, you still have to defend your lifestyle, your community, your resources from your own independent government of, you know, a multinational Hawaiian independent country, because there will be factions in that independent Hawaiian country that would want to invite global capital to come and do whatever it wants. And so you will still need the UNDRIP to protect the Kanaka Maoli in such a state.
Yeah. Okay. No, this clarifies a lot of the power and, like I said, the function of the Indigenous Declaration.
Right.
To
I hope so.
Its relationship, to the larger state.
Right. I really hope so. And I think the argument about either independence or a nation within a nation, or independence. First of all, you can't have independence and nation within a nation, but you can have eventual independence by already starting to apply the UN Declaration of the Rights of Indigenous Peoples. And all indigenous peoples should do it right now. And the Latin American countries are indigenous organizations are fantastic. They have already won at least 3 huge cases in their courts by invoking the declaration. And by the way, the Organization of American States is a forum that Kanaka Maoli might want to think about. You know, you don't have to say that you're part of the Americas to go there. You just have to say you're part of, you're being administered by the United States, which is part of the Organization of American States. And its human rights mechanism is available to individuals and collectivities that have a grievance and a claim against the states that are parts of the Organization of American States. And as we know, there are many, many progressive Latin American governments today. So when you pick your forum, you have to pick, is this the right time to pick this forum? Is this forum you know, more likely to be sympathetic than that forum? In my view, the Organization of American States, you know, has already shown it was sympathetic to the Rapa Nui request. They asked Chile to come and explain why it is doing what it is doing in Rapa Nui. So, you know, we have to both move here and internationally.
Yeah. I like that word. It's being administered by the United States.
Yes.
Because it creates that distance immediately.
Completely. I mean, that was the official wording for the U.S. presence under the UN from 1945 until 1959, when the U.S. you know, organized this non-referendum
Yeah.
in 1959, where, you know, Dick, Tom, and Harry, fresh off the boat from Kansas,
Right,
virtually can
right,
decide
right.
whether Hawaii should be independent or not, except that independence was not even an option.